Bruce Willis, who is America's favorite tough guy, was just told he has frontotemporal dementia, or FTD, which kills the frontal or temporal lobes of the brain. This is the most common form of dementia in people under 60. It affects people between the ages of 45 and 64. His condition shows how important it is to plan for being unable to work. Unfortunately, planning for incapacity is often put behind planning for what will happen when someone dies. This is because death is a sure thing, but incapacity is not. Its uncertainty, on the other hand, makes it even more important to plan for it. Like death, being unable to work doesn't care about your age, health, or family. It happens for no reason and usually without warning. When someone gets sick or hurt out of the blue, it throws their family into a panic. If the person who isn't able to take care of themselves didn't plan for this, their family may have to go through a guardianship process to have the person declared incompetent and a guardian appointed. Guardianship procedures are sometimes called living probate, because they are similar to probate in a lot of ways, except that the loved one in question is still alive. Let's look at a specific case. John decided he wanted to move closer to his parents, who were getting older. He put his house on the market, but on the way back from a meeting with the agent, he was in an accident that left him unable to take care of his business. One of John's friends knew that John wanted to sell his house and thought that his sister, who was looking to move, would love it. The neighbor's sister made an offer that was more than the selling price, but no one could legally accept it because John was sick and had not made a plan for when he was sick. His family asked the court to say that he was unable to take care of himself and to name someone as his formal guardian. The process was hard because John's family couldn't agree on who should be his guardian. The argument was settled in court, where some bad things were said about John and his family. Sadly, by the time a guardian was chosen, the neighbor's sister had already changed her mind. Shortly after that, home prices started going down, and John's family had to wait a few months before another buyer made an offer that was much lower than the last one and even less than the asking price. Even though the above example seems crazy, it's not. Every day, things like this happen. What are some things John could have done to stop this from happening? First, John should have made a power of attorney for real estate. A property power of attorney lets the owner, John, choose an agent, and one or more successors to make decisions about John's property on his behalf while he is still alive. The property power of attorney may give the agent the right to make these choices right away, even if the principal is not unable to do so at the time. Most states also allow the principal to make the property power of attorney springing, which means that the agent's powers don't start until the principal is unable to do so. When someone says that a property power of attorney is durable, they mean that it stays in effect even if the principal is no longer able to do so. If the property power of attorney is not lasting, the agent can't do anything while the principal is sick or hurt. John should have also made a healthcare power of attorney in addition to the property power of attorney. The healthcare power of attorney lets the principal choose an agent to make medical choices for the principal if the principal is unable to do so. The agent cannot, however, change any medical decision made by the principal. John should have signed a HIPAA authorization along with the healthcare power of attorney. This lets one or more authorized people get information that the Health Insurance Portability and Accountability Act of 1996 says must be kept secret. Even though it's important to keep health information private, people who are working on behalf of others need to be able to access it. The HIPAA authorization makes this possible. Lastly, John should have made a trust that could be changed. A revocable trust replaces a will, keeps the truster's privacy, needs little or no court supervision, and gives the truster a lot of freedom. If John had put his home in a revocable trust, the replacement trustee would have taken over when John got sick or hurt and managed the property. The new trustee would have been legally allowed to accept the offer on John's house, sell it, and then use the money from the sale to pay for John's continued care. This would have given John's home more security and made it easier to sell. Due to the risk of theft, financial institutions are often hesitant to use a property power of attorney for real estate, especially if it was signed more than 2 years ago. The revocable trust completely avoids the problem. No matter how long the disability will last, it's important to plan for it as part of a complete estate plan. Statistics show that more than 7 million people aged 65 and up are thought to have dementia. This number alone should scare us all into making plans for when we can't work. It's important to plan how your wealth will be handled after you die, but it's even more important to plan how your assets and health will be handled if you become sick or injured. As people live longer, there are more chances that they or someone they love will get sick or hurt. The person who can't do things takes a mental and physical toll on themselves and their loved ones when they can't. A smooth estate plan takes away these worries and the mental stress they cause, so everyone can focus on healing and the next steps. If you enjoyed the video, please like and subscribe, so you don't miss any future videos.